So good afternoon and a very big welcome to the next Your Employment webinar in the series, providing you with essential employment law and HR updates. And today's webinar is a special focus on the disciplinary process and tricky issues related to the same. For those of you that are new to our webinars, we are Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups, and also some fantastic individuals as well. And we're very proud to say that we have a very high success rate of the cases that we work on for those that we represent. And we're delighted to have you with us. Just before we begin, I'd like to quickly introduce the team and those that will be speaking today. We've got one of the firm's senior associates, Harriet.
Hi, everybody.
And we've got one of the firm's paralegals, Dominic.
Hi, good afternoon.
And returning for a second webinar, we got the firm's new paralegal, Jess.
Good afternoon.
All right, in terms of format for the webinar, if you want to ask us questions, and of course we have promised a live Q&A session at the end of the webinar, please use the Q&A box. If you want to do this anonymously, please hit the anonymous button. We will never read your full names out of the names of your companies on the webinar, but yeah, if you want to ask anonymous questions, you can. If you don't mind your name being displayed, you can use the chat box as well. None of this appears on the recording of the webinar, by the way, which I should add, we are recording the webinar, so people that couldn't make it at 4 o'clock today are able to watch it. And yeah, one of the good things to do as well is if you're asking questions, there's a drop-down box where it says the option is panelists or all panelists and attendees. If you select the second one, so all panelists and attendees, then everybody can see what your question is, and it's easier to keep the chat flowing that way. If you want to speak live, please write that into the Q&A or chat box, and either myself or one of the team can unmute you. And yeah, as I mentioned before, we are recording the webinar, so if you have any concerns with that, let us know. But yeah, we will never reveal your identity on the webinar either. I should mention that all the points that we're covering today are not formal legal advice, and so much depends on the facts of each individual case. And the approach taken in one case is not the same that you take in another. So if you're dealing with any particularly difficult disciplinary issues or dismissal issues at the moment, by all means drop us a line. We're more than happy to help you. And as a quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 20th of October 2022. Things are changing very quickly, so do drop us a line again if you have any questions. And lastly, if there's anybody else that you think would work well with this, or would like joining these webinars or receiving our newsletters, and definitely drop us a line. You can reach me, dean.jones@joneschase.com. Okay, brilliant. Well, we've got again so much to cover today. I think you could spend maybe 10 webinars discussing the disciplinary process. But moving quickly on to the content, I'm going to hand over to Jess, who's going to discuss the disciplinary process generally and one of the tricky issues. Okay, so over to you, Jess.
Thank you very much, Dean. So yes, I will be covering the disciplinary process generally, a bit of an overview, and then just go into one of the tricky issues. So the disciplinary procedure is a formal mechanism for an employer to deal with their employees' misconduct or capability. It's common for employers to have a separate procedure for dealing with capability or performance issues, although the ACAS code is clear that the basic principles of fairness should be followed regardless. Misconduct, on the other hand, is when an employee's unacceptable or inappropriate behaviour or action breaks the workplace rules. Examples of misconduct include bullying, harassment, refusal to do work, which is known as insubordination, being absent without permission, being persistently late. Different workplaces might have their own examples that are specific to the type of work that they carry out. In some cases, the employer might find that there's been gross misconduct. Examples of this include fraud, physical violence, gross negligence, or serious insubordination. Again, what is considered to be gross misconduct may vary across workplaces, and Dom will be covering gross misconduct in more detail later in this webinar. Before a disciplinary procedure is launched, the employer should first assess whether the problem can be resolved in an informal way. This is often quicker and much easier as a solution, and can include privately talking to them and the other staff involved, listening to their point of view, agreeing improvements to be made, and setting up a training or development plan if it's a performance issue. Very broadly, a formal disciplinary procedure should be as follows. So identifying the allegation or the allegations against the employee, investigating the alleged misconduct or poor performance, including obtaining evidence, considering the appropriateness of suspending the employee. This step may be considered early in stages of investigation, depending on the nature of the allegation and considering whether a fair investigation can be carried out whilst they're still at work. In most cases, an investigation report should be produced, which should include the basic facts of the investigation process that was followed, and the findings of the investigation. If the investigation identifies that there is a case to be heard, then that evidence should be shared and a disciplinary hearing conducted. Clearly communicating disciplinary hearing outcome to the employee follows. And then finally, providing the employee with a right of appeal. Importantly, the employer from the outset should understand the different stages of the procedure and the requirements of these stages without prejudging the potential outcome. It's important to act fast, but with due care and consideration, and plan ahead where possible. Before initiating an investigation, employers should also consider the ACAS Code of Practice and the relevant non-statutory guides, which I will discuss in more detail in a minute, the requirements of the company disciplinary procedure, and importantly, the legal status, the contractual status of that disciplinary procedure, who the appropriate investigator should be, bearing in mind the general requirement to have different individuals involved at each stage, and then any planned absences with any employees that are significant to the procedure or managers that will be involved. A disciplinary procedure is tricky and there is a lot to bear in mind. As a quick note, we do highly recommend seeking legal advice early in a disciplinary procedure and not waiting until a claim for unfair dismissal is received. Harriet will be discussing this in further detail later in the webinar, but it's worth noting now whilst discussing the procedure as a whole. So I will quickly talk about the statutory ACAS Code of Practice and the relevant uplifts and downlifts to compensation, which was also discussed last month, so in our webinar on grievances in the workplace. The ACAS Code will be referred to a lot today, as it was last month, as it sets out the basic requirements of fairness and standards of reasonable behaviour to be applied in disciplinary procedure. The code provides practical guidance to both employers and employees and should be referred to in any disciplinary procedure. As a quick reminder, failure to follow any part of the ACAS Code does not itself make an employer liable to proceedings, but failings will be taken into account by a tribunal when considering whether the employer has acted reasonably or not. In addition, and much like in the grievance procedure discussed last month, if an employee wins an unfair dismissal case, the tribunal can increase or decrease the amount of compensation by up to 25% if either the employer or the employee has unreasonably failed to comply with the ACAS Code. The disciplinary procedure in particular imposes far more obligations on the employer, and as they are the ones running the process, it's better to keep in line. Therefore, it is even more imperative for management and HR executives to adhere to the ACAS Code. In addition to the principles and standards set out in the code, employers should also be familiar with ACAS's non-statutory guides on discipline and grievances at work and the guide to conducting workplace investigations. So I will now turn to dealing with internal, contractual and non-contractual disciplinary procedures and sort of how they should be written into the contract or out of the contract. An employer is required to provide details on their disciplinary procedures as part of their obligations under Section 1 of the Employment Rights Act. A Section 1 statement, as we know it, is a set of particulars that a worker must be provided with at the start of or shortly after the start of any employment or engagement. In most cases, this set of particulars will form part of the employment contract. The Section 1 statement can either include details of the disciplinary procedure, or it can refer the employee to a reasonably accessible document. It is recommended for the employer to make disciplinary procedures non-contractual, providing them within a staff handbook or as a separate disciplinary procedure policy. In this way, an employer will be complying with the Employment Rights Act, whilst also protecting themselves from any breach of contract claims that may arise should they not follow their disciplinary procedure. Keeping the disciplinary procedure as non-contractual also makes it easier for employers to change it over time and where appropriate. If you need any specific advice on your disciplinary procedure, including making it work commercially for your business, we'd be very happy to assist you. As a quick reminder, Section 1 of the Employment Rights Act applies to both workers and employees. Therefore, details of the company disciplinary procedure should be provided to both workers as well as employees. But the ACAS Code of Practice applies only to employees, but it is good practice to follow the same principles of fairness and standards of reasonable behaviour in any disciplinary procedure, whether it involves an employee or a worker. So moving on to the investigation and whether you need to investigate every disciplinary issue. Much like in a possible grievance issue, the employer should find out all they reasonably can about the matters at hand. Generally speaking, a disciplinary hearing should only be arranged once a reasonable investigation has been completed. Put plainly, this is because a failure to complete an investigation is very likely to be seen as unfair. This is true even in the cases of obvious guilt, and sometimes even when the employee admits culpability. The extent of the investigation will vary case by case, but should be even-handed. In some cases, it may be possible to bypass the investigation stage, but this isn't recommended. So moving on to who should investigate the issues. In many instances, it might be appropriate for the employee's immediate line manager to conduct the investigation. However, this is not always the case. The employer's procedure will sometimes stipulate who conducts an investigation. For example, often large public sector employers will require that the investigation is conducted by a manager from outside the employee's own reporting line to ensure that the investigation is carried out impartially. Another appropriate option is to appoint a member of HR to conduct the investigation. This is often a good option because they may have training on the best way to conduct the investigation. Also, in some cases, it may be necessary to appoint someone with specialist knowledge of the employee's role or the alleged misconduct. For example, if the disciplinary relates to financial mismanagement, it might be suitable to appoint a finance manager. Much like a grievance investigation, the investigator should ideally not be a key witness unless this is completely unavoidable. When considering when this might be an issue, it could be worth instructing an external HR consultant. As always, the investigator should be impartial, as I've discussed. They should keep an open mind throughout the investigation and seek evidence that supports and weakens the employer's case. It is fundamental to the ACAS code that the investigator is not seen to have prejudged the outcome until the report is complete. The ACAS investigations guide available on their website provides further information on how to choose the investigator. So now moving on to who should chair the disciplinary meeting and whether this can be the same person as the investigator. The important rule here is basically that the person chairing the disciplinary meeting should not be the same individual who conducted the investigation. If the same person carried out both stages of the disciplinary, the decision maker may not seem very impartial. As a quick reminder, where the employee has been suspended, it is also preferable in a larger organisation if the person who took the decision to suspend does not conduct the disciplinary hearing for the same reason. This rule extends to any subsequent appeal hearings, and another thing is it's preferable to have a more senior level manager conduct each stage of the disciplinary procedure. When determining whether it is unfair for an investigator to also chair the disciplinary hearing and be the dismissal decision taker, the tribunal will have regard to the nature of the allegations, the manner of the investigation, importantly, the size, the capacity of the business, and other relevant circumstances. And this was considered in the case of Premier International Foods against Dolan in 2005. Who conducts each stage of the disciplinary should be considered at the very start of the procedure to ensure that there is no delay waiting for managers and HR executives to return from planned leave or during busy workload periods. So that's kind of the overview of the disciplinary procedure, and we will now move on to talking about tricky issues within the procedure itself and common problems that occur. I will be speaking about the first point, and then I will be handing over to Dom and Harriet for the rest. So the first thing to discuss is where there is a disciplinary procedure that relates to a criminal investigation or is running alongside a criminal investigation, and whether you need to suspend in those instances, whether you can suspend the investigation, just general things like that. So the general rule, where there's a police investigation, a criminal charge, or even a conviction that relates to an off-duty conduct, it's not necessarily a reason for an employer to take disciplinary action. The ACAS code and the non-statutory ACAS guide states that where the matter has no bearing on the employee's suitability for the role or their relationship with their colleagues, the employer or its customers, the employee should not be dismissed or disciplined solely for that criminal investigation charge or conviction. Where a criminal conviction leads to the loss of a license required for a particular job, and without that license, carrying out the job would be illegal, employers are encouraged to consider any appropriate alternative roles for the employee. The The company can consider doing something though if the organisation's reputation is at risk, and as these cases are quite complicated, we recommend that you proceed with caution. And is it appropriate to put the potential disciplinary proceedings on hold pending the outcome of criminal proceedings? Which, a significant problem arises where the employer may wish to put the disciplinary hearing on hold pending the outcome of the criminal proceedings. This may cause a particular issue where the employee has been suspended on full pay and the criminal proceedings are likely to last a number of months, if not years. The ACAS code is clear that the employee should hold any disciplinary hearing without unreasonable delay. In accordance with this, the non-statutory ACAS guide states that where the matter requires prompt attention, the employer need not await the outcome of the prosecution before taking a fair and reasonable action. However, an employee may sometimes refuse to answer questions, often on legal advice, as this may prejudice the pending police investigation. An employer should not interrogate an employee or pressurise them, but should carry out the investigation as fairly as possible. There is no rule that once an employee has been charged with a criminal offence, an employer cannot dismiss them if the employee has been advised to say nothing until the trial. We recommend that employers state in their disciplinary procedure that they will not usually wait for the outcome of any criminal proceeding before deciding what action, if any, to take. That's the end of my part.
Okay, thanks so much, Liz. That was great. And yeah, the introduction of simultaneous criminal and disciplinary proceedings always a very difficult issue. And as you said, some criminal cases can take years. And our advice on that point is each case will turn on its own facts. But I think the employer can, in some cases, move quite quickly, particularly if you don't want to suspend somebody for 12, 24 months to cost an absolute fortune. So you've got to be very careful is the message that we're going to get across today an awful lot. So moving on to Dom, who's going to discuss a number of other particularly difficult issues with the disciplinary process. So over to you, Dom.
Thank you, Dean. So as mentioned, looking at other tricky issues that employers need to consider. And firstly, looking at what to do if the employee goes off sick or states that the disciplinary process is making them unwell. So a common problem for employers is that of the employee who, on being told to attend a disciplinary hearing, absence themselves by reason of ill health, frequently citing stress and anxiety as the cause. The employer then has two conflicting priorities. On the one hand, there is a need to ensure that matters are dealt with without unreasonable delay, particularly if it is a serious case in which other employees' interests are involved. On the other hand, the employee may genuinely not be well enough to attend a hearing. The employer should also consider whether stress, anxiety, or depression may have caused or contributed to the misconduct or poor performance, and is usually more likely to be the latter. If this is the case, then it is advisable to consider dropping or at least suspending any disciplinary proceedings and assessing the situation using the health and safety executives' management standards where appropriate. So if the employee is still absent after a period of time, the employer may, subject to the employee's consent, obtain medical advice as to whether the employee is fit to attend a disciplinary hearing, and if not, when they are likely to be. This may be obtained from either the employee's own GP or an independent doctor, such as an occupational health physician. In the case of a GP, the Access to Medical Reports Act 1988 must be complied with. This may also apply to an occupational health physician who has previously treated the employee. It is advisable for the employment contract to contain a clause requiring the employee to submit to medical examination, but to be clear, this does not override the need for explicit consent. Failure to provide consent by the employee may be misconduct, but it is unlikely on its own to give the employer grounds for dismissal. Employees often expect that by getting themselves signed off with stress and anxiety, they can avoid disciplinary proceedings altogether. However, the medical view is often rather different. Fitness to work is not necessarily the same as fitness to attend a disciplinary hearing. The Department for Work and Pensions Health and Work Handbook states that it is likely the effects of an unresolved dispute on the employee's mental health may be greater if the proceedings are postponed. An employee may be unfit for work, but fit to engage with the management process. The doctor or nurse will have to assess whether attendance is likely to cause serious deterioration in the employee's mental or physical health. Occupational health reports are likely to recommend a postponement if the patient has severe depression, especially if there is a risk of suicide, or has only recently started taking antidepressants, or if any of the following criteria are not met. Firstly, does the employee have the ability to understand the allegations made against them? Secondly, does the employee have the ability to distinguish right from wrong? Thirdly, is the employee able to instruct a friend or representative to represent their interests? And finally, does the employee have the ability to understand and follow the proceedings, if necessary, with extra time and a written explanation? So with that in mind, can you hold the disciplinary hearing in the employee's absence? The employer may decide that the matter can wait, but it should ensure that issues do not remain unresolved indefinitely if the predicted return date keeps being extended. Sometimes in stress-related cases, the employees or their GPs will assert that no return to the workplace is possible while disciplinary proceedings are hanging over their head. It may reach the point at which no further delay can be withstood, keeping in mind that the absent employee may not be the only individual with an interest in the matter being resolved, and that the memories of witnesses may fade with time. In these situations, the employer must take a decision. If the matter is serious, this will mean that the employer may have to find an alternative way of proceeding with the hearing. This might mean conducting the hearing by telephone or at a neutral place or location near the employee's home address, or inviting the employee to submit written submissions and holding a hearing in their absence. The employer may also agree to the employee bringing a friend or family member rather than restricting them to a colleague or trade union representative. The employer should, as far as possible, take a pragmatic approach to attempt to secure the employee's attendance at a hearing. Of course, employers may have a very cynical view that the employee is deliberately pretending that they are sick to avoid the disciplinary hearing. This can happen a lot, and companies can take a commercial approach, push on and proceed with the hearing in the employee's absence. But if you do decide to go with this approach, you need to ensure that you've considered all the risks and you've covered cases. So now looking at whether your disciplinary procedure should have an appeal stage. So the short answer is yes. The ACAS Code of Practice on Disciplinary and Grievances states that employees should be given the right to appeal a disciplinary or grievance outcome. It is good practice to advise an employee in writing of the right to appeal when the employee's decision is communicated. Any deadline to submit the appeal should also be stated. The non-statutory ACAS guide recommends 5 working days as a reasonable time limit. However, the ACAS code itself does not specify a time limit, and employers should therefore ensure they consider all the surrounding circumstances before rejecting an appeal for being out of time. Additionally, the employer should also ensure that it complies with the appeal requirements set out in a contractual procedure. Failure to do so could constitute grounds for a successful constructive dismissal claim or a claim for unfair dismissal. Moreover, if an employer does not give the opportunity to appeal, this could be counted against them if the case goes to the Employment Tribunal and result in a 25% uplift to the compensatory award for the employee. The appeal can proceed as a review of the decision, which is much quicker and preferable for the employers, or it can be conducted as a rehearing, which is where the evidence and witnesses are reheard. And this is usually advised where fresh evidence has come to light or there have been procedural mistakes during the process. So turning to look at what circumstances you can dismiss a member of staff without giving them a disciplinary warning. So where somebody has less than 2 years service and there are no automatically unfair reasons for termination, such as whistleblowing, whilst a fair process should be followed in theory by way of best practice, unless an employer has a contractual disciplinary procedure, employers can take a commercial approach and dismiss somebody without giving them prior warnings should they wish to. Whilst this is not best practice as such, the employee will not be able to bring an unfair dismissal claim, despite the fact that a full process has not been followed. But where somebody has more than 2 years service, the following applies. An employer can just summarily dismiss an employee, thus without giving them notice, if the employee's actions result in gross misconduct. And that's something I will go into more detail exactly what that is shortly. But in ordinary misconduct and performance cases, an employee should ideally be given at least 2 warnings, a written warning and then a final written warning. In cases where the employer wants to summarily dismiss the employer must still follow a fair procedure to reach the conclusion. So when an employee is dismissed for gross misconduct, the employer has the option of getting the employee to leave immediately, ensuring the employee does not have a notice period, and not paying the employee notice pay. There are some things, of course, the employer must still pay them for, and these include any work that has not been paid for yet, any holiday they have built up but not used by the date they leave, otherwise known as accrued holiday, and any expenses they're owed. The employer may also need to pay them for other work benefits unless their contract states something different. So as I just mentioned, turning to what gross misconduct or gross negligence means. The ACAS Code of Practice on Disciplinary and Grievance Procedures states that some acts termed gross misconduct are so serious in themselves to have such serious consequences that they may call for dismissal without notice for a first offence, but a fair disciplinary process should be followed before dismissing for gross misconduct. Furthermore, in accordance with UK case law, gross misconduct amounts to misconduct of the most serious nature that undermines the relationship of trust and confidence. The court in Sandwell and West Birmingham Hospitals, NHS Trust and Westwood, stated that the act of gross misconduct must involve deliberate wrongdoing. Cases of gross negligence are less common than other types of gross misconduct. In Dietman and Brent, London Borough Council from 1987, a case concerning a social worker, the High Court commented that a working definition in the field of employment might be a really serious failure to achieve the standard of skill and care objectively to be expected from a social worker of the grade and experience of the individual. Interestingly, in Philander and Leonard, Cheshire Disability from 2018, the Employment Appeal Tribunal considered whether a tribunal had been right to categorise a case of gross negligence as gross misconduct rather than a capability issue. It said that the dividing line between conduct and capability can be paper thin and even porous. Some behaviours or acts or omissions which fall within the definition of extreme negligence can be considered as either capability matters or conduct matters and can be properly described as either. So the final issue that I will cover is the situation of dealing with disciplinaries after the employment ends. So can you or should you continue the process? So once an employment relationship ends, a former employer cannot compel a former employee to attend any disciplinary hearing. There is no longer any obligation on the former employee to obey the employer's instructions and no contract between the parties compelling the employee's attendance. Whilst an employer could choose to attempt to continue the disciplinary proceedings, there is likely to be little practical benefit in doing so. However, an employer may wish to proceed with a disciplinary hearing where a report to a relevant professional body or regulatory body may be required. In this case, the employer should ensure that the former employee is aware of the potential need to report when inviting them to the hearing. If the employee refuses to attend the hearing, the employer could potentially proceed in their absence. If the employee has already left employment, a finding at a disciplinary hearing that the employee would have been dismissed will have little practical effect and will not change the original reason for termination of employment. So finally, if an employee resigns, which often happens when they know they are guilty of something in the hope that the resignation will get the employer to drop the process altogether, employers can still continue with the process in cases where the employee is in their notice period. And in some instances, it is important to do that, particularly where the incident in question involves another employee. That's all for me.
Great. Thanks so much, Dom, as well. I'm just noticing that there's 0 questions asked so far. So for all the attendees, by all means, if you want to ask us questions, drop them in the Q&A box. Again, you can do that anonymously. If you want to do that, so you're there, I think there's a little option here, a tick box you can use for anonymous question asking, so you can do that. That was great. Thanks so much, Dom. I'm just going to hand over to Harriet now, who's going to discuss yet more complicated legal issues surrounding the disciplinary process. So over to you, Harriet. Thanks.
Thanks, Dean. Yes, a few more complicated issues. So the first thing I wanted to look at is suspension, because this is always a big topic and something that does need to be considered carefully. So suspension is covered helpfully in the non-statutory ACAS guide that we've talked about. So it's useful to have a look at that. And just in September, ACAS published new guidance on suspension, which advises employers how to consider and handle staff suspensions at work, specifically during investigations. So have a look at that as well, because it does go into a bit more detail. So where you've got an instance of serious misconduct, an employer may wish to suspend the employee who is under investigation. And it might be appropriate, for example, where there is a threat to the business or to other employees, or where it may not be possible to properly investigate the allegation if the employee remains at work. For example, they might destroy evidence or try and attempt to influence witnesses or sway the investigation. And it might also be appropriate where relationships at work have severely broken down, to the point that there seems to be a genuine risk to other employees or property, customers, other business interests if the employee stays in the workplace, or potentially if the employees are subject to criminal proceedings, which may affect whether they can do their job, which Jess has already spoken about. But I would caution that an employer should be careful not to give the impression of having prejudged the outcome, and shouldn't make a knee-jerk decision to suspend without proper consideration of all the circumstances, because I think suspension can leave people feeling prejudged, demotivated and devalued. So it should really only be used after a sort of very serious, careful consideration. And there will be lots of cases where suspension is not appropriate, and indeed the sort of ACAS guides say that it should only be considered exceptionally. And obviously you want to bear in mind the mental health of the individual who might be suspended, because it can be very distressing to be in that situation, even if they don't show any obvious signs of distress. So the ACAS guide does say that an employer should bear this in mind when deciding when and how to communicate a decision about suspension. And it's good practice to offer them some support. So think about how that person might be feeling. So some common issues that we come across, I mean, first of all, looking at what's the process for suspending, and it should always be as short as possible, and that decision always needs to be kept under review. Make it clear it's not a disciplinary sanction, and check. Sometimes employment contracts will talk about a maximum period for suspension. It's not so common in the private sector, but obviously make sure that what you're doing is in accordance with your contract or your policy, because if the period of suspension is too long, is excessive, then it may give rise to a claim of breach of contract from the employee, or in extreme cases for the individual to resign and claim constructive dismissal. And the first thing to check is whether or not suspension is actually permitted by the contract. We'd always advise that your contract does have an express right to suspend. That should normally be there, but do double check that in your contracts. And if there isn't a contractual right to suspend, you have to think about whether the nature of the individual's work might give rise to an implied right to work. And if that is the case, then if you suspend them, it could be in breach of contract. So it does happen in some cases. So an implied right to work might arise where, for example, the individual is otherwise not going to be paid. So if they do shift work, or get paid on commission, or there are cases where somebody needs to sort of maintain a public profile and needs to work for that purpose, which obviously is not massively common, or need to exercise their professional skills frequently, etc. So it's just something to bear in mind. But I think if there's no contractual right to suspend, proceed cautiously. What about the implied term of trust and confidence, which is really important in this area? The High Court has held that an employer's express contractual right to suspend an employee is subject to an implied term that right be exercised on reasonable grounds. So an employer should always be considering if there is an alternative to suspension before going ahead with it. So, for example, temporarily moving an employee to a different area of the business, maybe from there to be working from home if they don't normally, changing their shifts, etc. So you've got to make sure there's a reasonable ground to suspend, and probably keep a record of that reason and that decision-making process. And this is going to be particularly important, I think, in the case of senior employees, where the repercussions of suspension are likely to be even more serious. And just think about potential discrimination. You need to operate that suspension policy consistently. So if you've got 2 or more employees who are involved in the same incident of misconduct, make sure you're treating them consistently, particularly if there could be issues of discrimination arising. And lastly on this point, in terms of pay entitlements, normally they should continue to receive their normal pay and benefits. That's what you'd normally expect and you would normally see in an employment contract. I have occasionally seen an employment contract that says expressly that there may be no right to receive pay. That's quite unusual, but that right would definitely need to be in the contract if you were considering not paying someone during that period. So moving on now to the question of what if a grievance is raised, complaining about the disciplinary process itself. It is quite common for employees to submit grievances after they become aware that either their conduct or their performance is being investigated, and particularly once they've been invited to a disciplinary hearing. And this can obviously cause problems when deciding how to proceed, particularly if you suspect that the individual is raising this tactically to delay the disciplinary proceedings. And in our last webinar, we looked generally at the issue of grievances being raised during a disciplinary process, but more specifically, what if the grievance is about that process itself? Generally, the ACAS guidance says that it's up to an employer whether or not they're going to suspend the disciplinary process to deal with the grievance. But there are some situations in which it might be appropriate, and particularly when you're looking at complaints about the disciplinary process itself. So some examples could be if the grievance relates to a conflict of interest that the manager who's holding a disciplinary hearing is alleged to have. If there's bias alleged in the conduct of the disciplinary hearing, if the individual complains that management has been selective with the evidence it's supplied to the manager holding the disciplinary hearing, or if there's possible discrimination involved. So I think given the risk of the employee arguing that their dismissal is unfair or discriminatory if they are later dismissed or given a disciplinary sanction, it may be prudent to pause a disciplinary process to deal with their complaint if it's about the process itself, resolve it and then move forward. But it's very much going to depend on the facts of the case and weighing up the legal risks, as always, in terms of what's the individual's length of service, are there issues of discrimination, etc. Another topic that we often get questions on is what happens if witnesses are reluctant to come forward, and can you anonymise their evidence? Obviously, witness evidence is often crucial to an investigation, particularly where you've got cases where there's limited documentary evidence. And often the witnesses can be reluctant, and some say, well, I'm only going to come forward if you can make sure that the individual doesn't know that it's me who said such and such. So I think if you are asked this by a potential witness, first explore what is their reason for the request, see if there's any underlying motive there. And then I think, an employer really has to balance the request for anonymity against the accused employees need to know the details of the evidence for and against them, for them to be able to challenge that evidence, which is the basis of a fair hearing. The ACAS investigations guide states that an investigator should try to avoid anonymising witness statements wherever possible, because, as I said, the individual who's being investigated is likely to be disadvantaged if the evidence is anonymised, as it makes it very difficult for them to effectively challenge the evidence when they don't know who's given it. So ACAS takes the view that an investigator should only agree to anonymise a witness statement in exceptional circumstances, often where a witness has, for example, a genuine fear of reprisals. And if that's the case, steps can be taken to protect a witness's identity. But I caution the reality is that there's no guarantee of complete anonymity that can be provided to a witness, because depending on the facts, there may be a risk that a subsequent criminal or civil trial, including employment tribunal proceedings, would be issued. And if that happens, the accused employee will seek disclosure of witness statements or notes of interviews, which will then identify the witness. So I would proceed cautiously in giving anybody a guarantee of anonymity. So looking at being accompanied through these processes, what if the accused person wants their lawyer to attend the meeting with them? Can you refuse? Is that the situation in all cases? So as you'll be aware, employees don't have a statutory right to be accompanied at an investigation meeting, although it's possible a contractual disciplinary procedure may give them such a right, so always check that. But there's no general right under UK law for an employee to have a qualified legal representative at a disciplinary hearing, only a colleague or a union representative, as we've already mentioned. But there are some situations in which you might need to consider this. Some employees, for example, NHS hospital doctors, there's been a case about that, they may have a right under their employment contracts. So, if you're in the sort of public sector or acting in that area, that's always something to have a look at. If the employee might be disabled under the Equality Act, it may be a reasonable adjustment to allow them to be accompanied by someone other than a colleague or a union representative. So obviously that can apply quite broadly, and in theory this could include a lawyer. So always, consider what the individual is asking for and why. And then lastly, there are very limited situations in which an employee might be able to establish a right to a legal representation as a result of the Human Rights Act 1998. And this enshrines into UK law Article 6 of the ECHR, which is the right to a fair hearing in the determination of civil rights. So this would only apply where the outcome of the disciplinary proceedings would determine or have a substantial influence on a decision of a regulatory body or similar that has the power to bar someone from their profession. So, for example, a teacher, somebody who works in the NHS, for example, I think no cases have actually been successful relying on this that I'm aware of. But I did read that the Education Secretary, who knows who that might be from day to day, is examining plans to bolster the rights of teachers who choose not to join a union. So there is a proposal to amend the Employment Relations Act 1999 to give teachers the right to be accompanied to disciplinary and grievance hearings by an external lawyer or representative of a body other than a union. And I understand this was confirmed in a parliamentary written answer to an MP in April. So that might be something for the future, but obviously is only going to apply to very specific circumstances. Another point we want to just touch on is what happens if without prejudice points are raised. We did touch on this last time in relation to grievances. Often it crops up with disciplinaries where the employee decides that they don't want to go through with the process and can perhaps see that the writing's on the wall, particularly where there's an allegation of gross misconduct, and they want to see if there's a way to have an agreed exit to avoid being dismissed. So if the employee raises discussions about some kind of agreed exit like this during a disciplinary process, then these discussions would not be normally admissible in future litigation if the without prejudice rule applies. And as a reminder, this will apply where there's a pre-existing dispute which the parties are looking to settle. And if there's no pre-existing dispute, then without prejudice won't apply. And often with these situations, there isn't actually a dispute at this point. There's just an investigation into something that's happened. And so it may be more likely that section 111A of the Employment Rights Act might apply, which covers sort of pre-termination negotiations, in which case, if that's raised, you should pause any meeting in which it's being discussed, explain to the employee that it can be discussed on this basis if without prejudice applies, or under the Employment Rights Act, explain what it means, but carry the meeting on, but make a separate note, which won't be admissible, certainly in an unfair dismissal claim as regards section 111A. So if no settlement is reached, discussions can be easily separated from evidence about the disciplinary itself. So it's fine to have those discussions, but keep the discussion as a separate discussion and a separate record of it. And finally, I just wanted to have a word about legal advice privilege, which is probably something that you could start with, and it should start with right at the beginning of these processes, because what of any of these processes is covered by legal advice privilege can be really crucial in investigations in terms of the documents that are produced and what may later then be admissible in evidence if there's any later litigation. So just as a reminder, legal advice privilege applies to confidential communications which pass between a client and their lawyer, and which sorry, it's my speaker, and which they've come into existence with the dominant purpose of giving or receiving legal advice about what should be sensibly done in any particular relevant legal context. It's narrower than litigation privilege, which applies again to confidential communications between a client and their lawyer or a third party, and that's made for the dominant purpose of litigation, which is contemplated or ongoing. So often when you're doing a disciplinary investigation, there may not be any litigation even in contemplation. So what you're looking at is legal advice privilege, and this comes into play in a few ways. We often see that sometimes small employers may delegate part of the disciplinary process, and in particular the investigation, to external consultants. And this point also applies to grievance processes, which are outsourced. Often this is done to help ensure impartiality or because of resources, but it can mean that any legal advice privilege is lost. And this is in particular if the external consultant is appointed by an employer. The employer should bear in mind that communication, certainly between them and the consultant, and the external consultant and the consultant's lawyers, and the employer's lawyers, is unlikely to be covered by legal advice privilege. And this may be the case even if the external consultant also becomes a client of the external lawyers, which you can sometimes do that, but it's quite artificial to do that, and therefore there's a potential that won't work. So you need to be very careful about what's put in writing between any of those parties in those circumstances. And also, if a written report is prepared by a lawyer, which may be unlikely in the context of an initial internal disciplinary investigation, but might be more likely with a final outcome, that report won't necessarily be a communication made for the purpose of enabling the lawyer to give legal advice. So even if the lawyer drafts it, it's possible it may not be covered by legal advice privilege. And if the employer later attempts to rely on legal advice privilege to prevent the disclosure of a report or earlier drafts, the burden of proof is going to be on the employer to establish that the report itself was made for that purpose, the purpose of seeking legal advice. And it's not going to, neither form of privilege is going to have retrospective application to an original version of an investigation report, where the original report was not protected by privilege when it was created. There's been a very recent EAT decision on this, the case of Chakraborty, where this happened, and the employer was trying to suggest that the original version of an investigation report should be privileged because they sought legal advice on the subsequent version of the report. And the court was having none of that, so the original version was disclosable. And they were concerned, I think, because of potential differences between the original version and the version that the lawyers had looked at. So given these difficulties, an employer might, as a precautionary measure, want to add wording to any original version of a report, saying something like this draft of the report is created for the purpose of obtaining legal advice, if indeed it has been. But I think the thing I would finish on is, if you want to make sure that the documents may be privileged and therefore not disclosable, is instruct lawyers right at the outset of the process, and then make sure that they're involved in the creation of the documents, and the documents are sent to the lawyers for the purpose of obtaining legal advice. And then you've got more chance of those documents being legally privileged, particularly if you're looking at creating various drafts. But there are quite a lot of limitations on legal advice privilege, so it's just something to be across and bear in mind with all of this. And that's all I wanted to say on that.
That's great. Thanks so much, Harriet. And we're now coming to the part of the webinar where there's a live Q&A section. I genuinely thought we were going to be bombarded by questions on the topic of the disciplinary process. So far, we haven't had any questions in. It's for want of better expressions, one of the most popular processes that employers run. They're not very popular for the employees on the other end of them, of course. So I mean, by all means, if you have any questions, do fire them in. Whilst we'll give it a couple of minutes to see if any questions do pop in. I think we've never had a webinar without questions before. This may be the first. But whilst we're waiting for questions to come in, I'm just going to have a bonus section of the webinar just to disclose some, which I've just written whilst Harriet was speaking, some top tips for running disciplinary processes. For the team as well, any of the top tips, definitely throw them in at the end. Okay, so I've got one question in. I'm just going to run through these very quickly and see if there's any other questions coming in. So top tip number one is make sure that your policies are drafted in a very commercial way. The temptation is to follow best practice, but that's not very commercial. I mean, for example, having a policy that follows best practice and says things like every disciplinary issue will be fully investigated. It gives the company no wriggle room then. If sometimes you haven't got time to investigate, there's no people, you're very commercial steer here, but it's better to say something along the lines of the employer may investigate, or an investigation may be appropriate in a disciplinary case, just to give you a little bit of wriggle room, just in case in a very, very plainly obvious case. I was discussing this with Jess in the office earlier, and if somebody walks up to somebody in the office and punches them in the face and everybody witnesses it, you know, you could possibly proceed straight to a disciplinary hearing. Obviously, you share the evidence, but the investigation may not be necessary. So make sure your policies are written commercially, not in terms of best practice. Second top tip, it's a great idea to have a code of conduct, particularly contractual code of conduct, because there you can list a load of things, and we've got a great template as well. A whole host of the rogues gallery of bad behavior. And then if somebody does something, you can say, oh, that's in breach of section 5 of our code of conduct. And there it is, it's written there, plus you're in breach of contract. So having a code of conduct that works in tandem with the disciplinary process is great. Third top tip is obviously before proceeding, and sometimes there's a lot of adrenaline and excitement with the disciplinary process, make sure you get all of your evidence ready and checked at the investigation stage, ideally before proceeding to a disciplinary hearing. Don't proceed unless you're pretty sure you can see the thing off, I would say with that. Top tip number 4, great one to remember, avoid creating disclosable documents, okay? Far too often the cases we work on, there's been a load of chatter internally, people emailing each other saying this person's got to get fired, is awful, right at the start of the process, which is then evidence of predetermination, of prejudgment. All that gets disclosed to the tribunal, and it just ruins the process because it makes the process look very unfair. So avoid creating disclosable documents, have discussions, verbal discussions face-to-face over the phone rather than WhatsApp, text, or email. Obviously, using lawyers means the communications could be legally privileged, where relevant. It's a great thing to protect the company as well. And finally, for me, on this, something you can use if there's a clearly problematic employee that you want to get out of the business. If you don't have the legs legally to do it, you can make the case look fundamentally threatening and convincing and very scary with an invite to a disciplinary meeting letter, but at the same time offer to settle. And if the case looks convincing enough, you may be able to get the person to leave on a voluntary basis. I hate to say it, obviously you'll have to pay them some money, but quite often people forget that option's available, and there's something that we do on both sides of the fence as well. So yeah, you are able to, one tactic is to make the case look worse than it is. I hate to say it, I'm going to go down in flames for this, but if you've got to get someone out of the business and you haven't got the legal grounds for it, they've never had a warning before, they haven't committed gross misconduct, this is something that you can do. Okay, all right, we've got 2 questions in, and yeah, for the team, any of the top tips, we'll circle back on those. So trends we're seeing in these cases. Okay, sorry, yeah, from an anonymous attendee. So the question is, have we seen any trends? Well, just answering that one, I mean, the trend I'm seeing a lot at the moment, a load of cases being brought against male employees for sexual harassment, actually, and a lot of them involve people being in a workplace relationship, and then months after, a number of them, and Jess is working with me on a few, and so is Dom. But a number of months after the relationship has ended, oops, it's all gone dark, the female employee would complain, and then the male employee would be basically disciplined. But there's been a tendency on the part of the employer to presume the male employee's guilt before looking at the evidence, and our job then, acting for the individual, is to present a balanced view of the evidence. So we're seeing a lot of cases brought against male employees. Zainab, a colleague of mine, commented the other day that she only has male clients at the moment, just to give you an idea of the scale of this. So I know the Me Too movement is 5 years old now, but there's definitely a volume of cases against men coming through at the moment. I don't know, any other trends across the team? No. Okay, I mean, that's the obvious one that I've noticed. Okay, second question from Heather: extending a probationary period verbally, not in writing, how would this be viewed? So well, I can answer that unless anybody else wants to say anything. No, okay, I'll do that. Yeah, so the first thing you need to do there is to obviously check the contract, because the contract may have specific rules for extending probation or not. I mean, generally speaking, if everyone's happy for it to continue, then great. You can obviously follow up with an email and say, oh, just by the way, even if it's a number of months ago, by the way, your probationary period is extended until X date. So send something in writing anyway, just to clarify what's happening. But yeah, obviously check the employment contract. Okay, that's it. There's 3 minutes to go, and I don't think there's any other questions that have come in. And any other top tips from the team before we close up at the moment? No. Okay, so we've 5 bonus top tips on how to run disciplinary processes. Thanks so much for attending. We're going to finish 2 minutes early today, which is the first time ever. And obviously, the information that we've covered today is accurate as of the 20th of October 2022. If you need anything else, absolutely drop us a line. And of course, we're more than happy for news of these webinars to be spread. So if there's anybody else you think would benefit from being on these, definitely ask them to drop me a line, dean.jones@jonschase.com. And okay, until the next webinar in November, that's all from us. Thanks very much for attending, and we hope to see you soon. Okay, take care and bye-bye.
Bye.
Bye.